Hi, I'm attorney John Cannon of Cannon and Associates, and today we're going to be discussing what happens at your first court date, or what's typically called your arraignment in state court. An arraignment is your first opportunity to be in front of a judge. However, it's typically not the judge that will hear your case. At the arraignment, the judge will notify you of what your charges are. The court will notify you of what the punishment range is and ask you to enter a plea. This is your first formal opportunity to learn what you will be facing in your criminal charges in Oklahoma State Court. Also, when the court asks you what your plea is, it's very important that you enter a plea of not guilty. For one, the courts will typically enter that on your behalf. However, if you enter a plea of guilty, you've given away your opportunity to contest the state's case. You've given away your or your criminal defense attorney's opportunity to contest the evidence of the state or try and mitigate or negotiate your charges. Another important aspect of the initial appearance, also called the arraignment, is that your bond can be considered. Oftentimes in Oklahoma State Court, bond is set based on the initial charges presented by law enforcement to the sheriff's department. And that bond can sometimes be excessive, especially if the district attorney's office, in reviewing charges, determines that you should only be charged with one offense or less serious offenses than are brought to the office of the district attorney by law enforcement. So it's very important that you have a criminal defense attorney representing you, even at this early phase of the process, because an experienced criminal defense attorney would be able to have your bond set at an appropriate amount, which will make things for your finances as well as working with your bondsman easier during this process. So, one of the questions that we get very often is who is at the arraignment? Well, there's really three important parties in a criminal case at this point in time. There's the judge, the prosecutor, and the defendant. However, in most settings, the prosecutor is not present for the arraignment. Again, the prosecutor has the authority to decide to file charges or not file charges. And they decide based on probable cause if they think that they can make a case for A, B, or C crime against you in state court. Many prosecution offices will not file charges unless they believe they can win a jury trial. However, that's not the requirement to elect to file charges. So, once the district attorney's office has decided the charges are appropriate against you, they will file an information in the court clerk's office that will be sent to the court that handles the arraignment, and you, either through your warrant or your bondsman, will be notified you need to appear in court so that you can answer to your charges. Once the district attorney has presented that information to the court, they do not have to appear for what is basically your opportunity to hear the charges brought by the district attorney, to enter your plea of not guilty or potentially guilty if you're not present with an attorney and you're uncomfortable with moving forward in the process. But again, we highly advise that one, you retain experienced defense counsel, and two, you should always enter a not guilty plea at your arraignment. Entering a not guilty plea at the arraignment phase does not mean that you're unwilling to work out an agreement with the state or that you are contesting your charges to the bitter end. Entering a not guilty plea just at this initial phase holds the government to their burden of potentially presenting the case against you to a jury or to the judge. So again, oftentimes the arraignment will just be you, multiple other people that are facing new charges, and the judge. And so it's important to know that you should not speak substantively to your case. You should not make admissions about facts of your case. You should not try and raise defenses because although the prosecution is not present, there are other people that if they hear incriminating statements by you about your case and the district attorney's office or the prosecution finds out, they could subpoena that individual to testify as to your admissions that you make even at that early phase of arraignment. One of the other great benefits of having a criminal defense attorney at this phase of the process is in most courts, if the arraignment date is set based on potential charges and your charges have not been filed yet, your criminal defense attorney can have that arraignment date stricken. Meaning, as opposed to coming to court again and again and again, waiting for those charges decision to be made, your criminal defense attorney can contact the district attorney's office, find out the status of your charges, and if charges will not be filed by your arraignment date, they should be able to strike that arraignment date and have it reset for a later date with the judge that is handling the arraignment docket in the county that your case is presently pending in. So finally, the arraignment is the process to get the ball rolling. It's the first time your charges are official in court. It's your opportunity to find out what charges you are facing, what the penalty may be for those charges, and you'd enter a not guilty plea before the court so that if you've not retained an experienced criminal defense attorney, you'll have time to do that before your first official court date. And if you have retained an experienced criminal defense attorney, they can appear on your behalf, assist you in entering your plea of not guilty, get you to the front of that line at arraignment when there may be 10, 20, or even more than 50 people waiting to be heard by the court, and keep you informed throughout the process. I hope that this video on what happens at your first court date and how arraignments work in state court have been helpful for you. Please keep in mind that we'd be more than happy to walk you through this process or help explain it to you in more detail. For a free case evaluation or to have your questions answered in more specificity or more detail about what you or your family member are facing, please contact our office by phone, email, or you can reach out through our website for more information. Again, I'm John Cannon, your fierce advocate, and I hope this has been helpful to you.